Tuesday, Judge Tanya Chutkan just declared a federal emergency from the bench. Not a warning, not a strongly worded order, an emergency declaration targeting executive authority directly. I've been going through the filings since this morning. Here's what I found. According to court documents filed Tuesday, the order runs 47 pages. I pulled it, read the whole thing. The short version, a federal judge is telling the executive branch it overstepped badly. $340 million in withheld agency funds cited as exhibit. 17 separate actions listed. One judicial order to stop all of it. 3 branches, 1 collision. You saw the breaking alerts. Here's what they missed. Quick context. Judge Tanya Chutkan, Federal District Court, Washington, D.C., appointed 2014, known for running a tight courtroom. No theater, no speeches, just rulings. The issue? A set of executive actions issued over the last several weeks that plaintiffs argued dismantle congressionally authorized powers without legal basis. Timeline? Fast version. 3 weeks ago, the first executive order dropped. Broad scope. Raise flags immediately. 2 weeks ago, plaintiffs filed for emergency injunctive relief. DOJ pushed back hard. Last Thursday, oral arguments ran 4 hours. Chutkan let both sides finish, said nothing from the bench. Then, Tuesday morning, the ruling landed. 47 pages, effective immediately. That's the setup. Now, the documents went further than most expected. And that's where this gets complicated, because this isn't just about one order or one agency. The filing draws a direct line from specific executive actions to specific constitutional violations. That's a different kind of ruling. Now, the documents. Okay, the evidence. First document, filed Tuesday. I pulled page 12. It says, quoting here, the executive actions at issue constitute a systematic pattern of circumventing congressional authorization. That's not my read, that's the court's language. What it means in plain English, the judge isn't saying one action was wrong, she's saying the pattern itself is the problem. But here's what got me, page 31, different section entirely. The filing identifies 17 distinct executive actions taken between May 4th and June 2nd, each one flagged individually, each one cross-referenced against the specific statute it allegedly bypassed. 17 actions, 29 days, all documented. Put those together? Yeah, that's not an accident. That's a pattern. I went through this 3 times. The structure is deliberate. Agency funding withheld without congressional notification, 4 separate instances. Personnel removals executed outside the standard confirmation process, 6 cases documented. Regulatory rollbacks issued without the required notice and comment period, 7 actions flagged, all documented, all cited with exhibit numbers. Now, what nobody's covering. Page 39, buried near the end. The ruling references internal communications obtained through FOIA litigation, showing that at least 2 White House counsel advisors flagged constitutional concerns about 3 of the 17 actions before they were signed. Read that again. Concerns raised internally, actions signed anyway. That changes this, because it removes the "we didn't know" defense from the table before it even gets used. Fallout. Within 24 hours of the ruling, 3 federal agencies issued formal compliance notices. The Office of Management and Budget placed $340 million in previously withheld funds back into the disbursement pipeline. And the DOJ filed an immediate notice of appeal, which they were expected to do, but the speed was notable. 48 minutes after the ruling posted publicly. That was fast. And here's one more thing. The order includes a compliance deadline, not open-ended, not as soon as practicable, June 16th, 8 days from today. Each of the 17 actions must either be reversed, suspended, or individually justified with a written legal basis submitted to the court by noon on June 16th. That's not a suggestion. That's a court order with an enforcement mechanism attached. The filing specifies, failure to comply opens the door to contempt proceedings. Not implied, written directly into the order on page 44, paragraph 7. I went back and checked that paragraph 4 times. It's there. That's just the first document. I've got 2 more to break down in this video. Subscribe. I'm not done. And when the DOJ appeal filing drops, I'll pull that too. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. White House legal counsel and DOJ defenders say this ruling is judicial overreach. And honestly, some of what they're arguing holds up under scrutiny. Their argument, stated fairly, first, the president's authority over executive agencies is constitutionally grounded. Article 2 gives the executive branch broad latitude to direct, reorganize, and prioritize federal functions. That's not a fringe position. That's in the Constitution. Second, Congress has historically been slow, gridlocked. When statutory processes lag years behind operational needs, the executive has often stepped in, and courts have frequently allowed it. Defenders say Chutkan is applying a stricter standard than precedent actually requires. Former Deputy White House counsel Robert Driscoll, who served in the DOJ for 8 years, put it this way: courts routinely defer to executive judgment on agency management. Don't agree with all of it, but that's not nothing. What they've got? Supreme Court precedent in Chevron and its successors gave agencies wide interpretive room. Defenders argue that tradition extends to execution, not just interpretation. 3 of the 17 flagged actions involve national security adjacencies, an area where courts have historically been reluctant to second-guess the executive. Even the Washington Post legal correspondent noted, the scope of this order is unusually broad. When a publication not known for defending this administration says the scope is broad, that's worth registering. Look, I'm not here to tell you who's right. The plaintiff's interpretation, the evidence supports it. The pattern Chutkan identifies is documented, specific, and cited with exhibit numbers. The defense interpretation, there's evidence there too. The constitutional framework around executive authority is genuinely contested ground. This isn't open and shut. Both can be true. That's what makes this complicated. What I can tell you is what the documents show. And they show a federal judge who reviewed 47 pages of evidence, heard 4 hours of oral argument, and concluded that the pattern of executive action in question crossed a legal line. She didn't say it was close. She said it was systematic. That word, systematic, appears 11 times in the ruling. I counted. That's the bridge into what came next, because the ruling didn't just describe the problem. It prescribed the response in detail. This didn't come out of nowhere. Backstory, quick. About 6 weeks ago, the first signs of friction between the White House and federal courts started surfacing in D.C. District. A pattern of executive orders that moved fast and explained little. Legal observers flagged it. No action yet. About a month ago, 3 separate civil liberties organizations filed coordinated challenges. Different angles, same core argument. Executive actions bypassing statutory process. Judges in 2 other districts dismissed. Chutkan's court accepted. 2 weeks ago, the emergency motion landed. Plaintiffs argued delay meant ongoing constitutional harm. Chutkan set an expedited briefing schedule, unusual but within her discretion. A former assistant U.S. attorney who worked in the D.C. district for 11 years said, on record, when Chutkan sets expedited briefing, she's already seen something she considers serious. What happened between that filing and Tuesday's ruling? 4 hours of oral argument, 23 amicus briefs submitted. And apparently, those internal White House communications obtained through FOIA that showed up on page 39. Pattern that emerged across the 6 weeks, actions taken, then legally justified after the fact. Notifications to Congress either delayed or skipped. Agency heads given no formal legal guidance before implementing. Every time, it moved forward. until Tuesday. See where this is going? If the breakdown's making sense, hit like. It tells me you want more of these detailed document breakdowns, and it helps more than you'd think. Tuesday, 9:47 a.m. Eastern. Here's what happened. The ruling posted to PACER without advance notice. Motion for emergency injunctive relief. Granted. That's the first line. Legal community reaction? Immediate. What followed? DOJ filed notice of appeal within 48 minutes. Fastest response most court watchers had seen in this type of case. 3 affected agencies issued internal compliance guidance within 2 hours. White House press secretary held an unscheduled briefing by noon. 18 hours, that fast. Now, what everyone missed. While coverage focused on the headline, Judge halts Trump executive actions, something else was happening simultaneously. On page 44 of the same ruling, Chutkan appointed a special compliance monitor. Not a referee, not a mediator, a federal officer was standing to report directly to the court on whether the June 16th deadline is being met. Then, buried in footnote 23, the ruling references a second set of executive actions currently under separate review in the same court. Different case number, same judge. Chutkan's response to the DOJ's appeal notice? She didn't pause enforcement pending appeal. She denied the automatic stay request. Wasn't reactive. That was a deliberate judicial choice. You can see it in how the ruling was structured. The compliance monitor appointment, the hard deadline, the denial of automatic stay, those weren't afterthoughts. They were written into the ruling before the DOJ even responded. She anticipated the appeal, and she closed off the easy exits before they could be used. This is where it gets interesting. Don't go anywhere. What I show next changes the picture. Drop your prediction in the comments right now. Does this ruling survive the appeal? Then keep watching. Check back after you finish to see if you were right. What are experts saying? Former federal prosecutor with 14 years in the D.C. Circuit, emergency injunctions of this scope targeting executive branch action are extraordinarily rare. Plain English, this isn't a routine procedural ruling. It's a structural intervention. Judges don't issue these lightly. Another one, constitutional law professor at Georgetown, teaches separation of powers specifically. The compliance monitor appointment is the most significant element. It converts an order into an ongoing enforcement mechanism. Key there, this doesn't end when the ruling is issued. The court retains active jurisdiction and oversight. The executive branch is now operating with a federal monitor watching. Here's what's interesting. Even a former DOJ official who served in Republican administrations and has publicly defended broad executive authority admitted the internal communications cited in the ruling complicate the legal defense significantly. When someone from the other side of this argument acknowledges the internal communications are a problem, pay attention. Consensus among legal analysts: the ruling will face serious appellate scrutiny. Article 2 arguments are genuinely strong at the circuit level. The compliance monitor appointment is the hardest element for the DOJ to challenge on appeal. It's within Chutkan's standard equitable powers. The June 16th deadline creates immediate pressure regardless of appeal outcome. Non-compliance before an appellate stay is granted would be its own legal crisis. That's where professionals land. Not that the ruling is unassailable, but that the burden now falls on the executive branch to move fast, argue hard, and meet a specific deadline, all simultaneously. Useful breakdown? If this is helping you understand what's actually in these documents, hit like. It matters for whether I keep doing detailed breakdowns like this. Appreciate it. Why should you care? Real talk, how this affects actual people. If you work for a federal agency, receive federal grants, or run a nonprofit that depends on federal funding, pay attention. The $340 million placed back into disbursement covers 17 program areas, including rural infrastructure grants, public health initiative funding, and education department allocations that were frozen starting May 4th. That money was frozen for 34 days. Some programs had already restructured operations, assuming it wasn't coming back. Your practical situation. If you applied for federal funding and received a delay notice between May 4th and today, this ruling directly affects your timeline. This sets a precedent. Next time an executive action moves fast without statutory process, there's now a documented legal pathway for emergency injunctive relief with a successful template. Quick example. A federal contractor receives a compliance directive from a newly restructured agency. The directive conflicts with their existing congressional authorization. Under the precedent being built in this case, there's now a faster route to judicial review than existed a month ago. Not dramatic. That's how legal precedent actually works. Right now, roughly 2.3 million federal employees operate under the agencies named in the ruling. State governments in 14 states have already flagged the frozen funding as affecting their own budget projections. It hits within the next 8 days. That's the compliance deadline. Uncomfortable part. This case is about process, not just policy. That distinction matters to everyone, regardless of which administration you support. If executive actions can bypass congressional authorization without judicial check, that applies to every future administration too, not just this one. If you vote, pay federal taxes, or rely on any federally authorized program, you're part of this conversation, not trying to make it partisan. That's what the documents themselves suggest. What informed people are doing right now? Federal grant recipients are contacting their program officers this week to confirm funding status under the ruling. State budget offices in affected states are monitoring the June 16th compliance deadline. Legal teams at affected agencies are reviewing which of the 17 actions apply to their specific operations. Knowledge helps. The ruling is public. The exhibit list is attached. Pacer has it. How did the White House respond? Made it worse, honestly. The initial statement called the ruling an unprecedented judicial assault on executive authority and said the administration would vigorously contest every element. Quote from the press briefing, "This overreach will not stand." Reaction? The statement went out before the DOJ had formally reviewed the full 47-page ruling, according to two sources familiar with the timeline. Within 3 hours, the official line softened. The second statement used the phrase, "respectfully disagree," instead. The plaintiffs' lead counsel came back fast. The administration's own internal communications are in the record. Rhetoric doesn't change that. Then, the next development. Late Tuesday evening, a second set of plaintiffs filed a related but separate motion in the same court. Different executive actions, same legal theory. Chutkan now has 2 active emergency motions on the same constitutional question, not cooling down. The DOJ's appeal targets the D.C. Circuit. Expected briefing timeline, 10 to 14 days. But the compliance deadline is June 16th, before the appeal is likely to be heard. That gap between the compliance deadline and the appellate schedule is where the next pressure point lives, heating up. What's still unclear? 1, whether the D.C. Circuit will issue an emergency administrative stay before June 16th. They can move fast, but they haven't signaled speed here yet. 2, 3 of the 17 flagged actions involve national security adjacent designations. The ruling addresses them, but with narrower language. The DOJ will almost certainly argue those 3 should be carved out. Whether Chutkan agrees before the deadline is unknown. The D.C. Circuit has the DOJ appeal docketed, briefing requested by June 12th. The compliance monitor Chutkan appointed must submit a first status report by June 14th. The White House counsel's office is reportedly preparing a formal Article 2 brief, separate from the DOJ appeal, to submit directly to the district court. Date to watch, June 16th, noon Eastern. That's the compliance deadline. Should know significantly more by then. The second emergency motion, the one filed Tuesday evening, has an initial hearing scheduled June 13th. Two fronts, same week. I'll break down the next filing when it drops, the June 12th DOJ appeal brief and the Compliance Monitor's June 14th status report. Subscribe and turn on notifications. Both of those documents will move this story fast. Where we are right now. Emergency injunction is active and in force as of Tuesday, June 8th. DOJ notice of appeal filed. Case is now before the D.C. Circuit. Compliance Monitor appointed. First status report due June 14th. June 16th deadline. All 17 executive actions must be reversed, suspended, or individually justified in writing. Second related emergency motion filed Tuesday evening. Initial hearing June 13th. Scheduled June 12th. DOJ appeal brief due at D.C. Circuit June 13th. Initial hearing on second emergency motion June 14th. Compliance Monitor status report submitted to court. June 16th, noon Eastern. Hard compliance deadline on all 17 actions. June 19th. Plaintiff response to DOJ appeal brief. Not public yet whether the White House will pursue an emergency stay application directly to the Supreme Court if the D.C. Circuit doesn't act by June 14th. That option exists. No confirmation it's being prepared, but it's on the table legally. Clock's running. That's where we are. Judge Chutkan, an active injunction, a compliance monitor, a hard deadline, and two open cases. Surface read, a court slapping down executive overreach. But the internal communications on page 39 are the element to watch. If the DOJ's appeal engages that record, acknowledges what was flagged internally before those actions were signed, the legal calculus shifts. If they avoid it, Chutkan's framework is harder to overturn. And the second emergency motion, filed the same evening as this ruling, means this constitutional question isn't going to resolve cleanly in one case. It's spreading. I'll be watching the June 14th Compliance Monitor report specifically. That document will tell us whether the executive branch is complying quietly or contesting through inaction. Story's not over, still developing. Subscribe for the full picture, not just the alerts. When those documents drop, I'll break them down. See you.